Welcome to a new episode of the podcast Immigration Law. I am Avocato Fabio Losgerbo. Today we analyze a clear and important decision issued by the Regional Administrative Court of Emilia-Romagna, Section 1, Judgment number 254 of 2026, related to case number 114 of 2026 in the General Register, published on February 13, 2026. The case concerns a foreign national who entered Italy with a student visa. When his residence permit expired, he claimed that he had applied for a conversion into a work residence permit. However, the police headquarters rejected the application, treating it as a request to renew the student permit, and an expulsion decree was also issued. The key point is this: there was no evidence of a formal application for conversion. The document produced was only the receipt of payment of the administrative fee, not an actual request for conversion. Moreover, the employment contract began after the renewal application had been submitted. In other words, at the time of the request, the legal requirements for conversion were not in place. The court clearly stated that the administration had correctly assessed the case as a renewal of a student residence permit. And here a fundamental principle emerges: if a permit is granted for study purposes, the foreign national must demonstrate a genuine academic path. In this case, no university exams had been taken. That fact was decisive. Another interesting aspect concerns the language of the decision. The refusal was drafted only in Italian. However, the court reaffirmed a consolidated principle: the lack of written translation does not invalidate the act if the foreign national was able to challenge it in time and fully exercise the right of defense. Here, the appeal was filed within the legal deadline. The court also emphasized that the police headquarters has no obligation to assess on its own initiative whether the applicant might qualify for a different type of residence permit. If no specific request for conversion is submitted, the administration is not required to look for alternative solutions. The outcome is clear: the appeal was rejected and the applicant was ordered to pay legal costs. This judgment reminds us of a simple but crucial truth. In immigration law, administrative procedure is substance. Applications must be formal, timely, and supported by requirements that already exist at the time of submission. You cannot build a conversion afterward. If you come to Italy to study, you must actually study, and if you want to work, you must formally apply for conversion when you meet the legal conditions. See you in the next episode of Immigration Law.